that he does not have his identification card with him, and the defendant gave a fictitious name officially.
This is where the situation already starts going downhill. Giving police a fake name might seem like a quick way to avoid trouble, but legally it can make things much worse. In many states, including Texas, failure to identify or providing false information can turn a simple stop into a criminal charge. And here's the big question for you watching. Would you panic in this situation, or just cooperate and hope for the best?
Leroy, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop.
And now we're hearing details tied to a much more serious allegation: aggravated robbery with a firearm. Under Texas law, the moment a weapon is used during a robbery, the charge escalates to a first-degree felony. That means the potential sentence could range anywhere from 5 years to life in prison. So when the judge hears this description later, it's going to heavily influence how dangerous the court believes this defendant might be.
Pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and then stomp on him. Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine.
What's happening here is a probable cause hearing, which is basically the court's first legal checkpoint. The judge isn't deciding guilt or innocence yet. Instead, they're asking a simpler question. Is there enough evidence for this case to move forward? If the answer is yes, which it usually is at this stage, the case continues through the criminal justice system.
You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him, and the defendant gave a fictitious name of Fisher Leroy with date of birth January 1st, 2006. The officer ran the name through NCIC and found a DPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The DPS picture matched the defendant, and he was able to positively ID, and that's it, Your Honor.
Now we're moving into one of the most important moments in a hearing like this: bond setting. Judges typically look at three main factors when deciding bond: public safety, the likelihood the defendant will flee, and the defendant's criminal history. Based on what we've already heard, fake identity, running from police, and serious violent allegations, you can probably predict the judge's concern here.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
So the charging instrument was filed November 13th of 2024.
Did you catch that? Speeds between 90 and 115 miles per hour, and not just on highways, but through residential and business areas. From the court's perspective, this isn't just reckless driving. This becomes a major public safety issue, and it dramatically affects how a judge evaluates whether someone should be released before trial.
I think that you may well be right. In that case, it says here A Hendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024 did then and there unlawfully while in the course of committing a theft of property owned by yada 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 with intent to obtain and maintain control, intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle the day after our two cases. How? Oh, I guess that's how they caught up to him, right?
They must have him and they found him, and that's when they arrested him on that, and then got picked up on the, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he?
Yes, Judge. It says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business.
I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to be with me today, promising me you're not going to drive. I don't give a rat's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high. I'm going to set them at $20,000 each.
So can I make an argument?
Yes,
Okay.
absolutely.
you, Judge.
I don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is an absolute, just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but and I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today, promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop.
Okay, thank you.
All right. I need you to sign this for me. I need him to sign bond finish with Felicia, and then after that, it's pretty good. Okay.
Can we excuse?
Yes, ma'am. Good morning, Mr. Hodges. Did you run an NCIC on him, please? What all does he have open elsewhere?
Yes, Judge. I'll run it right now.
And then if you can refresh my memory with regard to our case as well, please.
Yes. In regard to open cases, it appears in Galveston, he has an open UCW, a DWI, and a collision involving damage to a vehicle equal to $200.
It says an FSGI, DWI, and the UCW.
Yes, Judge. And then in regard to this case, The officer responded to a criminal mischief and made contact with the complainant, where the complainant stated he woke up and realized his tree had been ran into. He checked the surveillance and observed the defendant's motor vehicle colliding into the tree, traveling at a high rate of speed, and observed the defendant appearing to get out of the motor vehicle, walk in front of the vehicle, then get back in. And the officer later observed tire marks damaged on the landscape leading up to the tree, damage to the bricks around the tree, as well as damage to the tree itself, leading to damage approximately $200 for the grass and bricks and $2,500 for the tree.
And this is like, it's in the middle of the night, right?
Yes, sir.
Right. Okay. What would you like?
Judge, I'm asking for the driving condition and the curfew. I get it, it sounds bad, but Judge, he's unable to work. He's an electrician. He works throughout the night sometimes.
Oh, I'm not, I don't want you out in the middle of the night, Mr. Hodges. You have 4 open cases and you're out. You already were given one chance when you got on bond for those 3 cases out in Galveston. Now you've picked up another case in the middle of the night.
Are we able to lift the no driving restriction then, and maybe do 5 to 10 p.m.? It's just the 6 to 6 kind of interfere with his work schedule, like I said, but I understand completely not wanting to drive at night.
What's the curfew now?
I think it's 6 to 6.
It's 9 p.m.
Oh.
No, I don't do that bad. It's 9 p.m. to 6 a.m. What do you want, Mr. Hodges? I'm not giving you in the middle of the night. I'm telling you now. You have 4 open cases. 2. This is a potential DWI, so it's really a DWI and a second DWI. And you want me to let you out in the middle of the night?
Can we just lift the no driving restriction, Judge? Because it's daytime from.
Can you run his license?
Yes, Judge.
It's not eligible, but he has an ODL.
Yes, Judge. I'm saying not eligible.
He has an ODL license, Judge.
Did he have an interlock in his car at the time when he got here?
I don't believe so.
Then I'm not going to do it because he's supposed to have an occupational. An occupational always needs an interlock.
It may have.
You're
Judge.
you're violating your.
But did you have an?
You're supposed to have an interlock as part of the occupational license. You're in violation of your occupational license.
It may not have required that, Judge. Because I'm not on the Galveston case. But
Show me. Do you have a copy of the occupational license?
Okay. I have the granting of the occupational driver's license. The reason it didn't require interlock is because he had it prior to this. He got it for tickets that were unpaid because he didn't have insurance. He has current active insurance. I have the ODL right here.
Who gave it to him? Is it a JP court?
Yes.
Can imagine knowing that he has that open DWI in Galveston and knowing that he has now picked this case up here where it has an alcohol. I can't imagine that they're going to let,
Right now it is still active. So are we?
I don't know how comfortable I feel with him driving. Are you Mom? Come on up, Mom. Come up, Mr. Hodges. Thank you so much for coming. How's it been not driving?
Not enjoyable.
Blows, right? Good. Wonderful. Because I want you to understand, it is a privilege. It's not a right. And we do everything in our power here to ensure that we don't kill anyone on the road. Watch the news. Every day, someone dies on our roads because of an alcohol-related collision. It's disgusting. And you're familiar with everything that he has open.
Yes, I also am familiar that one of my husbands was killed on the road by someone that was drinking as well.
It's disgusting. It's so sad, and I took his privilege to drive away because of what's going on with Galveston. And now here we have the same situation here. They didn't charge him with DWI here, but very well could have been. And so the idea is to get you to appreciate it, to really feel the pang of not being able to drive, because I want you to realize it is an absolute privilege, and it is a great privilege. And to live in a city this big without the ability to drive really, really blows. That's just it. And I don't know if you really appreciate it. You coming up here and just telling me, oh, I'm so sorry, I'm hurt. That's not enough.
This moment feels less like a ruling and more like a life lesson from the bench. Judges often do this in DUI or reckless driving cases, using the courtroom as a place to deliver a wake-up call. The message here is clear. Driving isn't a right, it's a privilege. But let me ask you something. Do speeches like this actually change people, or do they just become another lecture defendants tune out?
I need to know that you really do appreciate the fact of how big and powerfully awesome it is to drive. I'm not ready yet to let you drive. I need to see some kind of proactivity showing me that you really appreciate being able to drive. But as it stands now, it's been 30 days since he's had this case here open. He's got the 4 cases over there. And I can tell you now, the judge that granted that license, if that judge now knows all these cases are open, I would bet my pinky toe that that judge would revoke that license now. Because I don't think any judge wants their name on a license with that kind of baggage to it. So I'm sorry. If you need more time at night, I'm happy to give you a little bit more time past 9 o'clock.
It's not so much, excuse me, it's not so much the night, it's where he works being an electrician. He has to be there earlier in the morning. So
Okay, I'm happy to work with you. You want 5 in the morning? What time do you want?
5 would be better.
Okay, done. I'll give it to you. Show me that you appreciate the fact of driving.
How do I do that?
Use your imagination. Be creative. Ingenuity goes a long way, Mr. Hodges, but you coming up here and tell me, oh, I'm so sorry, does nothing for me. Actions speak louder than words, and it's only been a mere 30 days since you picked up this case, and not to mention all those other cases that you have in Galveston County. So you are traveling far and wide, and the danger to the public is far and wide as well. I don't want anyone to die under my book, and I don't want anything under my name with that kind of, I don't want that kind of baggage in my life. I have hard enough time sleeping as it is. Show me, and then we can talk again. But I really want you to appreciate it, and I don't think you do so far. Okay, thanks. All right.
I'm approaching on Noah Biza.
Okay,
This is set for bail review today. It was also set on Friday and it got rolled to today.
She's here.
She is here. Her bond was revoked and raised last week due to her picking up a criminal trespass. So she does have 2 ankle monitors on right now, and we would just be requesting that one of those come off. Obviously, she knows that she's not supposed to be within 200 feet of Stereo Live, which is the bar that she was trespassing at.
what I don't want is I don't want her out in the middle of the night. And that's why we have that on. And I'm paying for everything, so nothing is going to come out of her pocket. Come up, Ms. Bison. She had the open DWI, just doing whatever she wants to do. And now she picks up another case out in the middle of the night. Nothing good happens at 2 a.m. And I don't want you out in the middle of the night. And the only way that I can enforce that is with the ankle monitor. Because if I take that off, you can run amok and I have no idea what you're doing, where you're going, and what's going on. I'm like I said, I'm paying for it, so it's nothing out of her pocket. Either things. I take cost off of everyone so that it's never an issue. I know that and I'm sorry that it's uncomfortable. Well, I'm not really sorry, but actions have consequences. You now see, and I'm going to tell you, you violate conditions again. Get ready for that bond. It's going to sprout legs. It's going to be, you understand? Show me after a while that we can trust you and perhaps we can talk. But you're just now getting out of jail after violating conditions over and over. Thanks.
Understood.
Okay.
Thank you.
So you're now out of jail. You have a lawyer. It is your responsibility to stay in touch with them, and they will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, you're ducking and dodging, you pick up a 3rd case, violate conditions again, there goes the bonds. Do you understand? Okay, stay in touch with them, and they'll tell you when you have to come back to court. So I'm going to waive the appearance so that she's whatever you guys need.
Thank you.
Okay.
And she did just complete IOP, and then she is planning to enroll in SOP prior to potentially entering into any other program that the court might have available. So,
yeah, it's up to you guys. Whatever, I'm just here. I just want to make sure that she's not out and about and continuing to party. According to her, she wants to go to school for this. She wants to go to school that. If you really how old are you, ma'am? You have something that I can't buy. I have money, right? I've got a ton of money here, there. Steven's got a lot of money, babe. But you got something that I can't buy. You got something Bill Gates can't buy. You got something that Jeff Bezos can't buy. Do you know what that is? No. Age. And the reason is, all those guys would pay an arm and a leg to be able to take back time to have age. But what matters is what you do with the age that you have. If you do nothing, it's a complete waste. If you're going to school, and if you really care about the future, then you're going about it all wrong by continuing to pick up cases, partying, going to a bar and refusing to leave the bar because I've got to wait for my drink. This life is a journey. It can be a great journey, or it can be a rotten, miserable journey. And as a young woman, you should never, ever have to realize or depend on a man. You should be getting your education. You should be getting degrees. You should be getting knowledge so that you never have to rely on a man. Men suck. Men are dogs. And you need to be able to rely on yourself, because if a guy says that they're going to take care of you, great. But one day they may never be there. One day they may take flight. And if you don't have an education, if you don't have a career, if you don't have knowledge, you'll be destitute, penniless, always dependent on a man. Don't. Become a strong woman with knowledge, because then that life becomes a great life. Because this life is only about one thing. This. The almighty dollar. And if you don't have this, you ain't got shit. You know what I mean?
Yes, sir.
So get your knowledge. Stop picking up cases. Once that age is gone, don't come back. Thanks.
Your Honor, my client does have class from 5 to 9, 6 to 9, my apologies. And I know she has a curfew right now that is imposed. Would the court be amenable towards pushing that curfew back a little bit?
Show me proof that you're in college or that you're in class and that the class goes at that time. I'll happily give you time to go home. Of course. Yeah. But I'm not going to take your word for it. Show me that you actually enrolled. You got like either a syllabus or whatnot, and then I'll, of course. I'm always amenable to working around a schedule for school. Of course. Just show me, and then we'll do it. Please.
Thank you, Your Honor.
Of course.
May we be excused?
Yes, ma'am.
Thank you.
Miss Wickenhofer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watch it. Anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222. You already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11. I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations. This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I am asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So I don't think I can. Show me where you think I can, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says I can give you a non-disclosure, and I can tell you, Ms. Wickenhofer, I love it, and I've told you this before, I love it when people try to better themselves, right? If I can, I will, because I'm always about trying to make someone's life better, right?
Yes, sir.
But I have to follow the law. I can't just say, okay, I can't just rubber stamp and do it just for the sake of doing it. There has to be a law, because if not, they appeal it and I'll get overturned.
Yeah, I think it was
traditionally
the
happens.
points I said, because I was under a certain amount of alcohol in my system.
That doesn't, what matters is the ultimate result in the case. Did you plead guilty? Did you do a probation? Did you do a deferred? I think that the legislature even now made deferreds available for certain types of DWIs so that people don't get convictions,
I
right?
understand.
But, and we never do them, right? But you can, right? And it's surprising that no people do deferreds on DWIs.
Traditionally in Harris County, Judge, we don't even offer deferreds on DWIs.
But if theoretically, if you go without an agreed recommendation, we could, and I think that we may have. I don't remember, but
So they don't grant deferred here then in Harris County.
no, you can. It's
You have to pay more money, so it sounds like.
no, it's not about money. It's about, there are other options that are better
Okay.
for some. So
I think that's probably why I didn't do it, because they didn't give me the option to.
we always do, though. Every single case. I talk to every single person that comes up here, and I make sure, hey, look, you're making a lifetime decision. Are you sure that you want to do this? Because it's not Target. You can't return it once you do it.
Yeah.
I literally, every person I scrutinize, micromanage. That's why we're still here. It's 110 when most judges are gone by
I
now, right?
understand. People tell me.
I really care about everybody that rolls here, and I want everybody to get the great result. And I don't know what was happening in your life at the time when this happened. Why did it end up like this? Was there something other? Did you have other charges elsewhere? If you can show me in the law that I can, then let's talk. That means you got to get it,
In writing.
No. Go through the actual, this is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures, who is eligible for them. You have to read it, you got to digest it. You definitely are not, I don't think I can't give you legal advice, right?
Yeah, I understand. Something we could do, but I don't know. I just want something to be done. I just don't know what can be done. It doesn't sound like anything, which really sucks for me, but.
It does. Yeah, and the thing is that I even tell people that, within a certain amount of time, if you get buyer's remorse, within 30 days of doing something, we've really reopened cases for people who get buyer's remorse. But here, the case is 5 years old. I have no jurisdiction. Even if I wanted to reopen it to do something, I can't. The only advice.
Any service I can do, like any extra thing I can do.
What I would do is really go to a lawyer, you're going to have to spend a little bit of money, go to a lawyer and fine tooth comb non-disclosure law
Okay.
and see, is there an out? Is there this? Is there that?
Mm-hmm. Just ask questions. Okay.
You may have to like hire a lawyer to really dig into it to see what you can do. Okay. But I can't give you legal advice. I can't sit there and comb the code with you to see, is there a provision that would get it? Because there's so many little nuances here and there. Right. I mean, even so much as a 0.15 or above.
Mr. Avalon, good morning, sir.
Sir, you were in February charged with terroristic threat of a family or household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. You have the right to remain silent. Anything you say can or will be used.
Well,
Not you. That you have the right to remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through TIC and TIC and observed their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and date of birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officers. The law enforcement officer also found that that her name came back as a protected person from a recent violence incident. And ran the identifying information of the driver, also known as the defendant, that came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant and confirmed that one of the law conditions and the protective order was the defendant shall have no contact with the
So it's just the by virtue of so we had issued the no contact, right?
Yes, Judge.
All right, so Mr. Avilar, I'm going to find that there's sufficient probable cause to go forward. You have to understand that when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer. The lawyer can come to us and we hear things out and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
In Your Honor, we will be, we'd like to approach off docket tomorrow to try to have the MOAP amended. The state did in fact try to call the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
So what happened?
Terroristic threat. He appeared in PC court on February 13th. He received a PR bond, and next week he came in here for an arraignment. He appeared. He got a reset for April 23rd.
Right, but I'm showing now he's bond active after the new case. Why? Did they give him another PR bond?
No, this case was never.
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the new case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it.
Yes.
It was new court. His only reset is for April 23rd.
Mr. Woodward, my concern is that, they gave them a PR bond on the terroristic threat. I don't even show that a PR bond was given. Oh, here we go. On 213, now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man.
That's my speak. Could I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk to me because I don't want you to say something that hurts your case.
Sir.
I'll give you time to talk to him, but I mean, I can't, we do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that,
Yes, sir.
Are you on parole at this time?
No, sir, I'm not on parole, but I paid for my bond.
Hold on. So no PR bond and a terrorist threat. Okay. Let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can regroup, try to figure something out. So Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
Okay. So we'll roll you to tomorrow. We'll try to figure something out.
Judge, he's supposed to get released today because of the surety bond on the BPO.
Rep, I'm not giving him another PR bond when he picked up a VPO though.
Do you want me to revoke
The PR bond. Yeah.
No,
Your Honor.
Yeah.
I mean, I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that he and the CW they're in a relationship. They had an argument. She grabbed his hair first, was pulling him. Then he was grabbing her, but a text message was sent from an unknown number saying, "If you don't come home, I'm gonna fuck you up." Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor.
Of which one?
For the terroristic threat case.
I don't know. I guess what happened in the terrorist threat?
Yes, Your Honor. Find yourself one moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but she would be if they called back. I don't think that she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was from the threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come on. We all know the F word.
I'm going to fuck you up if you don't come home.
I understand that made during an altercation.
If you don't come home. It was made during the defendant admitted that there was an altercation and admitted that he told the complaining witness, "I'm going to fuck you up if you don't come home."
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door. I got you. I'm gonna fucking kill you. Complainant stated she was fearful for her safety. But before that line, it says they came from an unknown number. It says it in the summary.
Your Honor, it is further down in the summary of facts that there is an admission.
I mean, of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate it at the same time, And I think that's what the state is saying here, that he corroborates the actual text message saying that I'm going to go fuck you up. Right?
Yes, Your Honor.
Yes.
The problem is that we have him, he's still doing stuff on his own. I've told him not to do it, admonished him not to do it, and he's still,
Yes, sir.
In this life, when you do things the right way, good things happen. When you do stuff the way you want to do it in violation of orders, and you've been through this sufficient that No, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you PR bond after PR bond after PR bond, I mean, we have no teeth.
Yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid for
When
it.
you're on your VPO, but I'm not going to give you a PR bond when you're picking up a VPO.
She called me, her home had it.
I'm not going to, no. Like I said, talk to your lawyer first. Start telling us stuff because I don't want you to put yourself in your mouth when you think you're trying to help regardless. Now look, we can come back tomorrow. He's going to come here. We can try to work something out. But
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
Back tomorrow, we'll deal with it and we'll figure something out. So you'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm going to revoke it for now. Come back tomorrow. We'll talk. Do you have a place so they can reach out to the complaining witness so they can get a rip done by tomorrow, Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get
Okay,
it.
so can you try to do a rip between now and tomorrow? So we can try to figure out what she wants and then we'll go forward? Please. Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.